courtroom battles, shocking plea deals, and the future of one of hip-hop's most controversial stars, YNW Melly. Today we're breaking down exactly what went down with YNW Bortlen's plea deal, how it connects to the murder case of YNW Juvie and YNW Sakasar, and what this could mean for Melly's ongoing trial. If you think you've already heard the story, trust me, the details are wilder than you can imagine. Let's rewind. YNW Demons, better known as YNW Melly, rose to fame with his viral hit Murder on My Mind, a track that, ironically, foreshadowed the legal troubles he'd soon face. His close friend and manager, Bortlen Henry, also known as YNW Bortlen, was right beside him. Together, along with crew members YNW Juvie and YNW Sakasar, they were seen as the future of melodic rap. But in October 2018, tragedy struck. Juvie and Sakasar were shot and killed. At first, police were told it was a drive-by shooting. But as investigators dug deeper, the story unraveled. Prosecutors claim Melly was the shooter and that Bortlen helped stage the scene to look like a drive-by. This is the case that has haunted both Melly and Bortlen for nearly 6 years. Originally, Bortlen was facing 2 counts of first-degree murder, accessory after the fact, and multiple other felony charges like tampering with a witness and directing the activities of a criminal gang. In Florida, first-degree murder is a capital offense. That means if he was convicted, the mandatory penalty was life in prison, no parole. So Bortlen wasn't just fighting for his freedom, he was fighting for his entire future. Fast forward to 2023. Just 1 day before jury selection, Bortlen made his move. He accepted a no-contest plea. Now, let's break this down. No contest is not the same as pleading guilty. Instead, it means the defendant is not admitting guilt but accepts that the court can sentence them as if they were guilty. So, what does this mean for Bortlen? 2 critical things. The state agreed to drop the murder charges. Bortlen only pled to being an accessory after the fact, tampering with a witness, and unlawful use of a 2-way communication device. That's a huge deal. Instead of spending life behind bars, he was sentenced to 10 years in prison plus 6 years probation. With time already served, Bortlen could be out by the age of 30 or 31.
To me, look like on the 19 case as to the 2 counts of accessory after the fact, as well as to all 4 counts in the 23 case. These are going to be adjudications, 10 years Florida State prison, followed by 6 years probation.
That's correct.
6 years probation. All counts are run concurrently. All sentences run concurrently with one another. It looks like there's no restitution in the 23 case. In the 19 case, I'm reserving restitution and ordering it payable. That's going to be to Terry Bagley as well as Ashley Phillips.
Yes, sir.
So now have to
We've spoken to them and they don't anticipate there being any restitution, just because it's caution.
Okay, well, I'll give you 120 days to tell me the amount. If there's
Yes,
no
sure.
amount, you won't give me restitution.
They are present as well, too, so our reaching out to that form for them for that.
Okay.
If there's restitution, they can let us know.
Okay.
As of today, they said there is none.
All right, and state, is that the complete term? That's it?
He's also going to be giving it to Crawford, Your Honor, at a later time.
Well, is that part of the negotiated
Yes,
resolution?
It is.
So tell me how that works. Sure. Sure, come on up. Madam Clerk, this is not on. I'm going to put you under oath, and I'm going to ask you some questions. If I ask you something you don't understand, please let me know. I'll try to ask you a better question, okay? As loud as you can so the court reporter can get down all the answers, okay? Raise your right hand. Swear to tell the truth, whole truth, nothing but the truth? You can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether you understand what's going on?
Nothing at all. No, no.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State prison. Counts 3 and 4 are accessory after the fact of murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State prison. In case number 23-10643, CF10A, You're charged in count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first-degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first-degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. And count 7, unlawful use of a two-way communication device. As charged, that's a second-degree felony. The maximum penalty is 15 years in Florida State Prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct? Yes. And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first-degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir? What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State, you're going to null process count 2 and count 5.
Correct, Your Honor.
As it relates only to Mr. Henry.
Correct.
Okay. So, Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's a second as charged, I believe. It's a third except as it relates to a capital case, but I'm happy to
Ours
look it up.
has a third, as we discussed, so.
Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum time served.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be an adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you negotiate is the deal you negotiate, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy, whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon, because if you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon. But this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that. That's what you want to do. So, sir, has anyone forced you, threatened you, or coerced you into entering these pleas? If I accept your pleas, there will not be a trial in either one of these cases. Do you understand that? If I accept these pleas, there's a whole bunch of constitutional rights you are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to confront and cross-examine the witnesses against you. You have the right to appeal any decisions that I may have made up to this point or any rulings I might make in a future trial. But understanding by entering this negotiated resolution today, you are giving up all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions? Are you satisfied with all the work that they have done for you? Sir, I've got two identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms? And is that your signature on the back of each form? Sir, there's a few things that I need to tell everyone that I take a plea from. They may or may not apply to you. If you are not a citizen of the United States, these pleas will result in your deportation. Do you understand that? Under the provisions of the Jimmy Rice Act, if the offenses to which you are pleading are sexually violent or sexually motivated offenses, or if you've been previously convicted of such offenses, then these pleas will subject you to an involuntary civil commitment as a sexually violent predator upon completion of your sentences. Do you understand that? If these are the drug offenses, the Department of Motor Vehicles will revoke your driver's license for a period of 1 year. Do you understand that? Sir, paragraph 11 of each form that you sign reads as follows. I acknowledge that my attorney and I have reviewed any discovery disclosed by the state. My attorney and I are unaware of any physical evidence for which DNA may exonerate me. In other words, sir, if there's any physical evidence in the case that we could test for DNA, that DNA evidence would not tell me that you were not one of the people in that vehicle when these crimes occurred. But actually the opposite would be true. If there was any such physical evidence that could be tested for DNA, that DNA evidence would tell me that you were one of the two people that was inside this vehicle when these crimes occurred. Sir, do you agree with that statement? State, do you agree with that statement?
Yes, Your Honor.
Defense, do you agree with that statement? Mr. Henry, understanding everything that I have talked to you about up to this point, do you still want to go ahead and resolve both cases today, right now? Defense, is he stipulating to a factual basis for the purpose of each plea in both cases?
Yes.
And if he's entitled to a PSI, defense, are you going to waive that as to each case?
Absolutely.
State, is there anything else that you need me to do before I take his plea?
Wait, Your Honor.
Okay. So, Mr. Henry, again, two cases. We're going to do one at a time. In case number 19, 1871 CF10A, as to count 3, accessory after the fact to murder in the first degree, and as to count 4, accessory after the fact as to murder in the first degree. How are you going to plead, sir? Guilty, not guilty, or no contest? In case number 23, 10643 CF10A, as to count 1, tampering with a witness in a capital felony, and count 7, unlawful use of a two-way communication device. How are you going to plead, sir? Guilty, not guilty, or no contest? I will accept your no contest pleas as to each. I'm going to find a factual basis to support each based upon my review of each electronic probable cause affidavit as well as your stipulation in court here today. I'm going to further find that you have freely, voluntarily, and intelligently waived your rights, that you have knowingly entered each plea with the advice of competent counsel who you've told me that you are satisfied with, that you understand the nature of the charges and the consequences of the plea. Accordingly, and pursuant to the negotiated agreement, I will sentence you as follows. In case number 19, 1871 CF10A, as to count 3 and count 4, I will adjudicate you guilty, sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. I will impose mandatory court costs. Pursuant to 943.325, I will need a set of your prints and DNA. Pursuant to 938.27, I will impose a cost of prosecution of $100. Sir, I'm also ordering restitution in that case payable to Terry, T-E-R-R-I Bagley, B-A-G-L-E-Y, and Ashley, A-S-H-L-E-Y Phillips, P-H-I-L-L-I-P-S, and reserving as to the amount. I'm going to give the state 120 days to tell me the amount of the restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. That will conclude that matter. In case number 23, 10643 CF10A, as to count 1 and count 7, I will adjudicate you guilty. Count 7 is a sentence of 5 years in Florida State Prison. Count 1 is a sentence of 10 years in Florida State Prison, followed by 6 years of reporting probation. I will impose mandatory court costs in that case as well. I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to 943.325, I will need another set of your prints and DNA. All of these, there is no restitution in that case. All of these sentences, all counts, both cases, will run concurrently. That is at the same time with each other. I will give you credit for all the time that you have served. State, in 1871 CF10A, your announcement as to counts 1 and 2.
The state will be announcing a null process to those counts, Your Honor.
And in case number 23, 10643 CF10A, state your announcement as to count 2 and count 5.
The state will be announcing a null
think that concludes all the matters. State, is there anything else that you need me to do regarding Mr. Henry in either case?
Just if you just have one moment.
I'm looking at the plea forms. The 23 case, they have 707 days credit for time served. In the 19 case, 1,340 days credit for time served.
Nothing else, Ryan, we just have the order for you as well.
So listen, the fee hearing docket is at 3:30 p.m. So
We've already spoken with BSI, we're just in an order, you can about a week.
okay. I mean, I was going to make it available if you wanted to do it now.
I think BSI is probably.
Okay. So they're in charge.
Just coordinate it with us.
Yeah.
Thank you, Judge.
Anything else from the
Here's where things get controversial. Many fans instantly assumed Bortlen's plea deal would hurt YNW Melly. After all, doesn't pleading to accessory mean he confirmed something shady happened? Not exactly. Bortlen's lawyers made it clear he did not admit to murder. By pleading no contest, he's legally guilty of helping after the fact, but not of pulling the trigger. This means two things for Melly. The prosecution cannot use Bortlen's plea as direct evidence that Melly was the shooter. In fact, Melly's defense might try to spin this to say, look, Bortlen already admitted involvement after the murders. That doesn't mean Melly did it. So instead of crippling Melly's defense, some argue this could actually strengthen it. Let's be real, plea deals are about survival. Trials are unpredictable. Juries can surprise you. Even if you think your case is strong, one bad witness or piece of evidence can destroy it. For Bortlen, the risk was massive. Gamble at trial and face life, or take the deal and guarantee release in less than a decade. His lawyers called it a fair resolution. And in the world of criminal law, this kind of plea deal is very common. As for YNW Melly, his trial continues. He's already faced a mistrial once, and prosecutors are determined to push forward. But with Bortlen out of the murder equation, all eyes are on whether the state has enough evidence to prove Melly pulled the trigger. His defense is expected to argue that the real responsibility lies elsewhere and Bortlen's plea might become a tool in that strategy. So, what do you think? Did YNW Bortlen just make the smartest move of his life, or did he throw YNW Melly under the bus? This case is far from over, and the drama is only heating up. Hit that subscribe button, drop your thoughts in the comments, and stay tuned as we follow every twist in this wild story.
Mike, can you hear him over there? Or do you want to do it? Yeah, Mr. Henry, just you can stay right there with your lawyers. Just speak loudly, okay? So we want you to hear me. Raise your right hand for me, please. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name and spell your full name.
My name is Bortlen, C-O-R-T-L-E-N, H-E-N-R-Y.
Okay. Sir, you may inquire.
Thank you, Judge. Mr. Henry, we just want to talk about what happened in the hospital on October 26, 2018. Do you recall driving to the hospital? You got to speak up and answer yes or no. So this is happened.
Yes.
Okay. And then at some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6. Minimum, 5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving? You were there for a little bit before they got there.
Oh, wait, before you said
The detectives.
the text when we talked to
And describe to me the room that you were in. Was it were you there by yourself with other people in the room?
It was like a private hospital room. Probably maybe like 4 different officers in the room. They had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
It was one of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing in the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yes.
And at any time, were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave? What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They wouldn't let me go.
Prior to you giving your statement to the officers, the detectives, at some point were the handcuffs taken off?
Yes.
Why?
They wanted me to go take, they wanted me to go to
The urine set?
Yes.
Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you out one of the
One
officers?
of the officers, one of the deputies that was standing guard in the room, they walked me out and walked me into a separate bathroom, restroom outside.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room? And then at some point, there are two detectives that come. Right? And at any time during your interaction with those detectives, did they tell you to agree to leave? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
It's not as cancer.
No, I'm not aware.
You say you were handcuffed. How long were you handcuffed for?
Then most of the time I'm dead. In the room close to the hospital.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until they said I'm dead. Until they said I could leave, so I could leave.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what's being marked as states for evidence. Do you recognize this picture? Who's that a picture of? Or where are you? Are you wearing handcuffs in this picture? This time move states B to evidence of states 2.
Any objection?
No objection.
Without objection, states B for identification is not going to be in evidence. That's States Exhibit 2, only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyo after the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday,
Yes.
out to where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm going to object, it's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir. You can answer the question.
You did not ride with Detective Toyota.
I didn't ride in the front seat.
You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home? No further questions.
All right, based on that, any redirect?
Judge, just briefly on the photo.
Yeah, let's go first.
Mr. Henry, this photo that you were shown of you in the hospital, do you recall a picture being taken of you?
That moment.
Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken off?
Objection, Your Honor, I said he doesn't recall this decision.
Hold on. Over the state's objection. Go ahead, sir. What's your answer to that question?
That was after
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After. No further questions.
Based on that, any recross?
No.
Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friend came to pick me up.
Someone came and picked you up from the hospital?
Yes, sir.
And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th of 2019.
All right, State, based on my questions, do you have any additional questions?
No,
Defense, based on my questions, do you have any additional questions?
No, Your Honor.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, Your Honor.